Good afternoon, everybody. My name is Sean Byrne. I'm the Acting Commissioner of the Division of Criminal Justice Services, and I appreciate everybody's attendance today at this Commission of Forensic Sciences meeting. We have a full agenda and a lot to cover, but before we get to the agenda, I want to take a moment to give very due respect to a member of this commission, somebody who's been on this commission since it was created in 1995, a member of the commission who actually participated in the negotiation of the bill that created the Forensic Sciences Commission, and that's Ivar Goldart. And Ivar, I have something from the governor for you and a plaque for you. So
I'm glad I have my lawyer with me.
I want to read this to you. This is signed by Governor Patterson, and it's presented to Ivar Goldart in honor of your outstanding service and leadership on the Commission on Forensic Sciences. Since 1994, your consummate guidance and sage counsel have helped raise standards, performance, and accountability in New York's forensic science laboratories, and have resulted in many invaluable and enduring contributions to the state's criminal justice system and your fellow citizens. On behalf of all New Yorkers, please accept my profound appreciation for your exemplary work and my best wishes for the utmost future success and happiness. Signed, David Patterson, Governor of the State of New York.
Very kind.
In addition, there's a plaque recognizing your many years of service. Would you like to say a few words to the commission?
I'd just like to say that among my memories as a practicing attorney, my time with this commission will be recalled as among the highest callings I've ever had. It's been a great honor to work with all of you. And I can only say I'm very humbled by this. I wish the commission future success. It's been a wonderful too many years to recall. And thank you very much. And thanks to the my thanks to the governor and for his kind words. Thank you.
Here, our pleasure. Congratulations. The next order of business is to review and have the approval of the meeting agenda. Does anybody have any requested changes to the agenda? Hearing none, I request a motion to accept the agenda as presented.
So moved.
Seconded? Okay. All in favor?
Aye.
Okay. That was moved by D.A. Fitzpatrick and seconded by Dr. Stajic. All right. The next item is the approval of the minutes of the December 11th, 2009 meeting. Has everybody had an opportunity to review that? Okay. Any comments or discussion? If not, I would like to take a motion to accept the minutes. Ivar Goldart, seconded. Kathy Corrado. All those in favor?
Aye.
Opposed? Okay. Okay. Moving on from there, I do want to point out that we have three new members of the Commission of Forensic Sciences that are starting today. We have Superintendent John Melville from the New York State Police, and Gina Bianchi, who is now the acting director of the Office of Forensic Services at DCJS, and myself as acting commissioner for DCJS. The next item, Barry, perfect timing.
Sorry, we got stuck in the elevator. I was with the police department.
Well, you missed the approval of the agenda. Next item, which is the first substantive item, is the review of the laboratory updates and accreditation issues. And Kathy Levine, if you could walk us through that, please.
The first laboratory for discussion is the Nassau County Medical Examiner Office, Department of Forensic Genetics. This is just an update on their accreditation. They are appealing one item, so they have had to go through ask for an extension of their accreditation. And in your packets, you'll see that we had a letter that it would extend their accreditation through July 12th. Yesterday, we heard that from John Nooner at Accredited Lab that the board of Accredited has extended that accreditation for another 3 months through to October 12th. And that will give them enough time their appeal is still in process, and that will give them enough time to get a conclusion to that appeal, as well as correct any remediation if they need to. So there's no vote required on that. That is really just an update.
I was confused as to what was the issue?
That they're appealing, Barry?
Yeah.
Yeah, me too, I didn't.
It's on the FBI QA audit. The question is, do the lab reports include the following elements? And the element for 11.2.6 is a quantitative or qualitative interpretive statement. In their reports, they use the term cannot be excluded. And that the auditors had some concern whether that was an inconclusive statement, which would require statistical interpretation. So the laboratory, the Nassau does not use that as an inclusion, but that's where there is some disagreement.
Is it possible for us to actually get the substance of what the dispute is? Because from the face of it, you know, they can appeal this, but it just seems to me that it's pretty clear that what they're asking for them is what they should be delivering. I mean, especially if it concerns DNA testing.
Yes.
No, you can't have a DNA report where they say you can't exclude somebody. They've got to give a number. That's ridiculous.
Do we have somebody from Nassau County
We do have the
that would like
lab
to comment on this?
director and assistant lab director here. Pat Buffalino is the lab director, and Karen Doolin, the assistant lab director.
I didn't mean to be cast aspersions, but maybe you could explain to us what the issue is.
That's okay,
Let me pull it out so we can read. Our issue is not so much the statement. Part of what our issue is, which was stated in our letter, is that we were being held to something and a standard that doesn't state such, and we seem to be potentially being held to guidelines that were just released in January.
The other
So that
issue
was
that
more of our appeal.
the other issue that we had was that we didn't feel that it deserved or was deserving of a level 1 car, and that's another portion of the appeal.
I appreciate that there may be stigma associated with having these kinds of statements made because they just changed the standards in accordance with the NAS report and proper scientific procedure, that you can't just say can't be excluded, you've got to give a number. But plainly, you've got to give a number, right? I mean, you're not just testing that. Are you guys going to start giving numbers?
We will be changing that statement to a different statement.
To an inconclusive, more of an inconclusive statement, but at the same time, it's also the level of car that we had issued with.
Well, look, I think we got a real problem here, because it's a real waste of time to go back and start fighting this with that class lab, because to say something is quote-unquote inconclusive, that also is meaningless scientifically. And as a matter of fact, if you look in the newspapers, you'll see that there was just a successful civil suit by Jerry Miller, who was somebody that was wrongly convicted in Chicago based on, he was excluded by DNA testing, real perpetrator was identified, but the city of Chicago just paid $6 million because the lab was just giving the statement quote-unquote inconclusive when it came down to serology reports. So you don't want to be in a position where you're giving statements like that. You know, either it matches, either there's a basis for saying, you got to give reasons, you got to give numbers, and you can't say inconclusive.
If I may, the SWIG-DAM interpretation guidelines for forensic DNA testing laboratories came out in January, where you can use cannot be excluded, excluded, inconclusive or uninterpretable.
Yeah, I know.
And
Well, we should
So-
have a debate about that, because that's just nonsense. I must tell you, I don't care if it's in the SWIG-DAM guideline, it has no scientific meaning. Either there's a reason that you can't say that, you've got to give a statement about, you know, we can't say that we can call the following alleles as real alleles, we can't call others, we're saying that there's allelic dropout, so we can't say anything. You got to give real reasons, and you got to give real
We will
numbers.
be.
I don't care what SWIG-DAM says.
Part of our remediation does include an explanation as to why something will be deemed inconclusive. But again, we felt that we should exercise our right to appeal, again, because of the level of call.
I'm not disputing that. I can understand why you feel the way you feel about, you know, the stigma attached with getting that kind of a thing, but I would just suggest maybe we could put it on the agenda for having a real discussion about this, because, you know, regardless of what the SWIG-DAM guidelines are, here in New York State, we ought to be following scientific practices that I think we all can agree are clear, you know. It sounds to me like you're giving real explanations. You would know more about this.
Well,
Kathy?
I was just going to state that the SWIG-DAM guidelines are national guidelines that are generated by experts in the
Yeah.
field, and that's what the field is following. In addition, there is the DNA subcommittee. If you want to maybe discuss something more, that might be the first more appropriate place to do that.
I accept that. Maybe we should have a discussion there, because.
This was discussed at the May 19th meeting.
And the subcommittee signed off on it.
Well, the subcommittee, at that point, they just knew, they felt that the finding would stand. You know, they did not think that it was going to be overturned by the INDIS board. So, you know, that was just that was their feeling on that. So the INDIS review panel has already looked at this and did not overturn it. The next step is to go to the INDIS board or ASCOD lab, and that's where the appeal stage is now.
Well,
So it might not be overturned at all, so.
Yeah.
And the fact of the matter is that they are remediating it. They're
We're
not arguing.
remediating it.
I understand. All right, I'm not quarreling with you, but I guess my quarrel is the SWIG-DAM guidelines that allow you to say that something is quote-unquote inconclusive without a further explanation, or to say that when you have a DNA test where you can give real numbers, to say can't be excluded, right?
Well, no, if you say can't, I think the SWIG-DAM guidelines say if you're saying can't be excluded, you need
That's
to
an
give the numbers.
inclusionary
All
statement.
right. Yeah, I give the numbers, okay. All right.
All right.
Now I know what this is.
Next item, Kathy?
The next laboratory is the Westchester County Department of Labs and Research Division of Forensic Science. And they had a surveillance visit for their international accreditation, and that visit was on January 20th to the 21st. And they had no issues with their surveillance assessment. So there's really just, that's, I think, included in there, in your packets. However, at the time of their surveillance, they did do an extension of scope, and to include the testing categories of audio and video analysis. And because the extension of scope changes their accreditation certificate, that will require a vote, because their New York State accreditation needs to mirror whatever ASCOD Lab International has. So I don't know if there's any discussion on that.
Hearing no discussion on the extension of scope of the Westchester County lab.
I
Can
actually
get-
have a question.
Okay, sure.
Are there any other laboratories in New York State that are accredited for this discipline of digital and multimedia evidence? Or is this the first one?
This is the first one in the video and audio.
Yeah, my laboratory is accredited in that, but in computer.
And Westchester Department of Public Safety is in computer as well, but this is the first one in that subdiscipline of video and audio analysis.
And I would just love to see what that is, you know, just because this was one of those disciplines that I think the NAS report questioned or thought that there were conflicting standards and thought that there should be more discussion or investigation. For the record, I'm looking at Mr. Schechter, or future member who was a member of the NAS report. Maybe he could help me with what that was, but it just, I don't want to hold up something that's, you know, I don't want to make life difficult for lab directors and hold up the bureaucracy, but I'd sure like to know what this is. Maybe we could have some discussion at our next meeting and report, because the NAS is suggesting maybe it's not even a proper discipline, or standards have to be set for this. So.
This is, they're doing enhancement of the audio, video and audio recordings that they might have, and, you know, tapes for security.
Yeah.
So that's really,
That's what I thought.
that's really what it is. And the lab director is here, Bob O'Donnell, if you need specific questions answered, I'm sure he can help you. But that is it is a discipline, a subdiscipline acknowledged by ASCLD Lab, so.
Right. So what are we actually being asked to do?
Because when they're accredited in the ASCLD Lab International, they put down every discipline and subdiscipline. Because they're added this, that changes their accreditation certificate for New York State as well as for ASCLD Lab. So we just need to get a vote to change that accreditation certificate.
Right, but this would be the first laboratory that's accredited in this field, right?
In this subdiscipline.
I
Kathy?
think, I don't know if you recall, but we discussed this when this came up for the provisional accreditation, and I know Director Adamo spoke about what they were doing, and at the time, I think it was something that was maybe different than what you're thinking.
It's not image, it's not analysis per se, it's more enhancement. For example, if we get an audio tape and there's a lot of background noise and the investigators want to hear what was said, there are computer filters that can actually pull out the background. We don't interpret anything. We basically give them a cleaned up version of usually garbled either video or garbled audio, and that they make the interpretations. We make no interpretations. And one thing I'd like to point out is that, yes, we are the first laboratory in the state, but this is being done by other private groups in New York State. It's also being done by law enforcement. We rose to the level of going after accreditation, putting ourselves before ASCLD, being inspected, taking competency tests, having our members thoroughly trained so that we could do the right job and provide the right information, or the best quality information for law enforcement. You know, if you were to take it away from us today, there would still be plenty of people out there doing it, and probably not doing it to the level we're doing it. So we're at least providing law enforcement with a set of standards that they realize that when they provide us with a videotape or an audio tape, they're going to get a quality result back.
I have no reason. Sounds to me like you're being commendably aggressive in trying to do something in government service that you're absolutely right are being offered by private vendors. My only concern is that what I read in the NAS report is there's some concern about just the standard setting for the discipline generally. So I guess what, the way this works is that ASCLD may have just come out with, or maybe for some time, have had this subspecialty where, you can get accreditation for it, right? But I don't think we've ever really looked at this to see whether we think in New York State it's appropriate. So I have no doubt that once we hear all about it, we'll probably think it's okay, but I'm just a little reluctant, because on the one hand, I have this NAS sort of warning that there's a problem with it, potentially, and I don't know, I can't say I really know anything about it, and I'd like to, so.
Dr. Jennings?
Yes, perhaps along those lines. There is a qualification to the extension, page 2 of 4. There's a note that during the on-site assessment, it was determined that the imaging services currently supplied by the lab do not meet ASCII lab definition of image analysis.
Right.
The lab may certainly continue to provide those services, but not as a recognized accredited
Right, we
category.
don't do image analysis per se. Photograph, where you measure people in pictures and things like that, that we don't do. So I think that's what they're saying. We basically, if someone gives us a fingerprint and they need a blow-up of the fingerprint, we'll do that. We're not doing photo analysis, so when we put in for image analysis, I guess we were mistaken as to what image analysis was, and they basically said, no, you're not doing image analysis, so we're not going to accredit you in it. Not that we were doing it poorly, just we're not doing it, so you're not going to get accredited in it. For the audio and video analysis part, they said, yes, you are doing, that is proper to ask for accreditation in that. You do have the ability to do that, and that's what we got inspected.
Okay, so this is poorly stated. It suggests that, in
Yes.
fact, you are doing image
No, no.
analysis that falls outside the scope
Right,
of
yeah.
ASCII.
Other discussion?
One additional point in the comments, ASCII Lab suggested that the lab should consider arranging for additional training in
Yes, we
audio
just-
analysis.
In fact, last week, we had 4 of our members attend an audio analysis program, a workshop.
Do you know what, well, certainly you know, what prompted that recommendation as a
Um,
result of their on-site?
They just felt that a little more training in that area, because we had stressed the video analysis. So the only reason for that is there's more video analysis training out there. So we looked and we got a grant to pay for audio analysis training. We went out and found a company that would do it. It's actually a worldwide company that trains a lot of people, and we sent 4 of our people to that. So they just completed that last week.
Thank you.
Any other discussion? There's no vote required on this, so. there
Yes,
is-
the extension.
Oh, I'm sorry, for the extension of the accreditation, my mistake. Could I get a motion then to extend the accreditation for audio and digital subdiscipline for Westchester County?
So moved.
D.A. Fitzpatrick, a second.
Second.
Gina Bianchi. All those in favor?
Right.
Opposed?
I'm going to abstain, because I
Fair
must
enough.
say, if you could provide us with, some more materials on this, I'd really appreciate it. I don't want to be an obstructionist, but I have absolutely no idea what this is about,
Okay.
so.
We'll send you the materials.
That'd be great, thank you, John.
Kathy?
The next laboratory is the Onondaga County Center for Forensic Science, and this is just a change to their scope of accreditation as well, and all they have is they remove the discipline of question documents from their scope, and so therefore, because it's a change in their scope, it requires a vote as well, so we can change their New York State accreditation.
Could I just ask why you did that?
Right.
This was
Of
basically.
accreditation from ASCLAB. Note 1, what's the significance of stating that fire debris material is examined in the same work unit as general controlled substance analysis? What's the nexus?
Peter, what are you, what are
He's
you
talking about
referring
note,
to?
he's talking about note 1, Kath, on categories.
Note 1, in this lab, testing category 4.10, which is fire debris material, is conducted in the same work unit as general controlled substance analysis. What does that mean?
That just means that we do ignitable liquid analysis, and that's done by the personnel in the chemistry section. That's the group in our building that performs the ignitable liquid analysis.
And that's the general controlled substance analysis unit also?
That's correct. That's drug chemistry. That's where they use the same equipment, and they have different procedures, different policies, but it's the same people in the same unit, using the same equipment.
Right. Why was it worthy of note?
Because some laboratories do their fire debris analysis in a trace evidence section. So Accredited Lab, when they do their assessment, they want to know which area that the fire debris analysis occurs in.
Okay. All right. Thank you.
To answer Mr. Scheck's question, it was a resource issue. The county last budget season went through some significant reductions in staff, and every department was asked to reduce staff, and as well as the crime lab was also asked to do that. And we looked at the work that we did, and we looked at the productivity of all of our sections, and that section actually did the least amount of work, and we had to reduce staff, and we had one person that did that, so we reduced it by that person.
So it had nothing to do with any doubts about the discipline itself?
No.
Where do you go for such services now?
Well, that is an issue. Currently, I believe there might be one other lab in New York that's doing that. Maybe you would know better, Kathy. But the FBI does offer that service. And there's also, again, there's a number of private individuals that are not accredited that do that within the state, and they're legally able to do that.
So who makes that call now, the district attorney?
Yes, or the police agency, I guess, depending on.
And thank you for waiting till after my last murder trial was completed, which I utilized the handwriting expert very well, I might add, Barry. You probably think that Hauptman didn't write the ransom notes, right?
That's a very interesting question.
General,
Yes.
general question or comment. So, in your laboratory, obviously this testing was held under high standard of conduct. You are now in a position of having to refer that work to another. This applies to you and to any other laboratory that finds it needs to refer work. What assurance and what process is in place to verify that the quality of work product remains as high as it was in your own laboratory?
Well, I personally don't refer the work. I mean, that's out of my control. If they're not submitting to my laboratory, they're submitting to somewhere else, and that's up to the people that are utilizing those services to determine that. I don't subcontract that, or we just don't offer that service anymore. And unfortunately, the police agencies and district attorneys have to find someone else to do that work for them.
So what guidance do they receive on where to send their work?
We give them the options of other laboratories that do it, and again, the FBI laboratory performs that service, and if they choose to use them or someone else, that's really their prerogative.
And those other providers would be for fee, including the FBI?
I don't believe the FBI charges. I think the private providers do. There are a number of private providers that do that offer their fee for service support fee.
Any further discussion? Okay, can I get a motion then on the change of scope of accreditation for the Onondaga County Center for Forensic Science? Dr. Stachik?
I'll second.
Okay, Myra Goldar?
Regretfully.
All those in favor? Opposed? Abstained?
Abstain.
Okay. All right. Next on the agenda, we move on to old business. The first item on the agenda under old business is the partial match issue. We have a binding recommendation letter from the DNA Subcommittee from the chairman, Jack Ballantyne, Dr. Ballantyne. Is there any discussion on this point?
Yeah, first, I apologize for not being here when we approved the minutes. I assume that you approved the minutes?
We did.
Okay. I would just like to note for the record that I think that the minutes are, they're not inaccurate, but there are descriptions there about, a lengthy discussion was held, right, about certain points. And I just want to make sure that I have a correct sense of what happened the last time. First, a motion was made that is a precondition for going forward with these rules and regulations, that we get a legal opinion letter from the Attorney General. And a vote was taken, and that was voted down.
That's
Okay.
right.
But I did not interpret that to mean that other members of this commission could not, on their own, make a request that the Attorney General issue a legal opinion with respect to the lawfulness of this activity. Nobody was saying that, right? Just want to be clear about that.
Of course not.
Okay. And because during the course of that discussion, I think that certainly Judge McQuillan and I believe Mr. Goldart as well, both at the meeting and in letters that we had sent, indicated that, A, we believe that it is unlawful, it is a direct violation of New York law to reveal the identity of an individual whose sample is in the database unless there is a DNA profile that matches an item from the crime scene, and that just is contrary to the statute, and the commission does not have the legal authority to do that. And part of also the, so I hope nobody is offended, or I just wanted to make clear that, you know,
You said that last
we
time.
intended to do that, and I just think the minutes should reflect that, so nobody's surprised when we do that, as well as ask the speaker and the majority leader of the Senate and the governor to consider that issue. Because I think that in terms of administrative law, once, assuming that this is, you know, passed and put into effect, that there is a procedure by which that some commentary period and some review can be taken of that. Secondly, one other thing that I just think the minutes should reflect that remains an abiding concern, and that is that, and I want to make sure that I've got this right, Ms. Carter, because I think you were the person that gave an answer to this at the last meeting, and that is, as far as the data banks that are being held by the medical examiner's office, I believe your Onondaga County, and others, maybe as many as 6, 7, or 8 DNA laboratories within our state have a data bank that is not part of the CODIS system, right, where DNA profiles are kept that include sample, elimination samples, suspects, even DNA samples from victims, and I guess consensual partners, although I suppose that constitutes an elimination sample. And
I'm sorry, is that a question, or I didn't?
no, I believe that this was part of the discussion, right? And I just want the record to be clear, because I believe you were the one that answered this question. We should all be clear that there is absolutely no rule or regulation in these guidelines or anywhere in New York State that would prohibit familial searching of the samples in that data bank, which could be in the tens, if not hundreds of 100,000 at this point statewide, right?
I don't recall if I answered that question or not. I mean, I think maybe what you're speaking to is, it's my understanding, and maybe Gino could answer this better, legally, that the laws that we're talking about don't pertain to the local databases.
Correct.
Right.
The statute does not cover the local data banks.
Which, you know, I think that's right. I think that's the issue. I think that's a problem. Whatever regulations, rule or regulations are going to be approved now for the CODIS system, albeit I think in violation of state law, but at least there are rules and regulations on how partial matches are going to be done, and presumably by preemption, there's prohibition on familial searching. There's absolutely nothing, I want the record to be clear, because I said this the last time and I want it clear, there's absolutely nothing governing the thousands and thousands of samples that are in these offline, for lack of a better term, data banks. Nothing. And I just want the minutes to reflect that that's a serious concern, and I would commend my colleagues on this commission. This is unacceptable. That, I mean, you could tomorrow, not saying anybody does it, but tomorrow you could be conducting familial searching of how many samples, Dr. Prince, are in the New York Medical Examiner's data bank?
We have 22,000 samples in our database. Of those, 6,000 to 8,000 are suspect samples. And the evidence samples are under CODIS regulations. To clarify this, because I believe I was the one that's in that
I'm
last
sorry.
meeting, but I don't have access to the minutes. So, but I do recall that we discussed this. But the samples in those local offline databases that are questionable are the suspect samples. But there is really no investigative reason to do a familial search on a suspect sample. It's my understanding a partial match release is if you get an almost match to an evidence sample. The suspect samples are all knowns. I honestly do not understand why there would be a reason to search that database that contains known samples for relatives.
Right. But just to be clear, what I think the issue is, and I know that this is going on in other states, you may have a victim, right, or a suspect, but you certainly have evidence samples, so it's a victim and it's others that are collected from a crime scene. And you have those DNA profiles in the data bank. And then there is a new crime committed, okay? And there's an evidence sample taken from the new crime. One could run it within the data bank and do a moderate stringency search or whatever you want to call it, and then you would find that the new crime scene sample matches at 10 or 11 markers from the DNA profile that's in the data bank. So even if that's an evidence sample from a crime victim, that information is telling you that the new crime arguably is committed by somebody that's related to the person whose evidence sample is there. So, isn't that right?
Yeah, now I understand, but for the record, we do not have victim samples, elimination samples in the database, but I think, and now I understand, you would
Yes.
search the new
Nor-
evidence against the suspect
That's
as
right.
compared to searching against the criminal.
Right, and all that I'm saying is that I have no doubt that if you tell me, Dr. Prince, you don't have victims in there, I accept your representation, because I always accept your representations. But there is nothing in writing anywhere. There is no legal regulation of any of this. And that's just, it seems to me bizarre that we're debating this whole partial match policy and all the privacy considerations involved in that and the legality of whether it violates state law or it doesn't for this system when we have all these samples and databases that are completely unregulated and have that exist in a legal netherworld. And I would just move, I think we have to regulate these in some fashion or form, or disband the databases or get the state legislature to act on it. So I'm just, that wasn't in the minutes. I said it the last time. Thank you for the clarification, Dr. Prince.
We'll note in the
It was
minutes.
you who gave the answer.
We'll note in the minutes of today's meeting that you brought this clarification forward about the minutes from the last meeting, and these meetings will reflect that.
Thank you very
Okay.
much.
I do want to go back to one thing you said about writing an opinion to the Attorney General. You would do that not on behalf of the Commission on Forensic
No,
Sciences.
seeking.
Yeah, just
Seeking an opinion.
on your own behalf or as a professional in charge of the Innocence Project or something like that, but not
Well-
on behalf of the Commission of Forensic Sciences, right?
No, I think that what we had indicated in letters, and I say we, I'm talking about the signatory, I think was Judge McClellan. I mean, I just have to tell you that Judge McClellan, as I'm sure you remember, Sean, for years wrote the commentary when we used to have books, you know, the commentary to the criminal procedural law and the penal law, and I think is one of the eminent scholars of New York state law, and Judge McQuillan feels very, very strongly that we have been acting illegally here. And so it was our intention, as I think we indicated in the letter, to call this, to ask the Attorney General to call this to the attention of our elected leaders, and obviously we're writing in our official capacity because we're bringing to the attention the vote we lost here. I mean, let's face it, we lost, I don't know, what was it, 4-2?
4-7.
4-something.
What?
4-something.
7-4.
7-4. We lost 7-4, okay? We have a number of scientists here. They're wonderful scientists, right? They're not lawyers. Bill Fitzpatrick and Judge McQuillan can disagree about what the law is, and ordinarily there are courts that tell us who's right or wrong.
Yeah,
right?
but I've been on this commission for
Yeah.
I don't know how many years, and I don't want to ask somebody in the Attorney General's office, with all
No.
due respect to them, for their opinion on something that I've been researching for 2 years.
Listen,
I think what we did is perfectly legal, and eventually there'll be a case that whoever the attorney is will challenge the legality of how the information was obtained.
yeah, I'm not disputing that. Obviously, the people that wrote these regs want to get on with it, and we've debated it here, and we've lost the votes across the board, and that's fine. All that I'm saying is that the fact that we took a vote here about what the law is, is comparatively meaningless.
I don't disagree with you that there may be a need for legislation at some point in the future, and you and I have privately discussed that, and we'll continue to do so.
So, David, I just want to make it clear, that's what we said we'd do, that's what we're going to do. And I was looking at the minutes, and I realized we lost the vote on whether the Attorney General should opine on this as a precondition, which I understand and accept. But I just wanted to make it clear that we're going to do what we said we were going to do, and that is ask for an opinion and bring this to the attention of our elected leaders anyway.
Okay.
And I didn't think anybody was binding us and preventing us from doing it, but I just wanted to make that clear.
Okay.
Thank you.
Further discussion on partial match? Okay. Although the Commission previously approved the amendments to the partial match regulation and implementation plan in conformance with Executive Law 995B, approval of the binding recommendation from the DNA Subcommittee is required to comply with the statute. So is there a motion? Bill Fitzpatrick, District Attorney Fitzpatrick. A second?
So moved.
All those in favor?
Oh, is he going to make his motion?
Yeah, do you want? I wrote it out, Sean, because I just wanted to be a little more precise on it.
Is the motion to approve the binding recommendation by the DNA subcommittee?
Yeah, I was just about.
It is. I don't think any motion is required.
I was just
by
about.
the commission. It's just a binding recommendation by the subcommittee.
I was just about to more formally make. Murphy, wake up! I was just about to more formally make the motion. I move to adopt the binding recommendation of the DNA subcommittee dated March 5th of this year, which allows disclosure of a partial match, provided that such disclosure complies with existing state and/or FBI guidelines, and that disclosure is made in a manner consistent with the protocols and reporting requirements that were set forth in the regulations of the implementation plan, which we approved at our last meeting. So that's my motion.
May I make a comment?
Yes, please do, Judge McQuillan.
Yeah, we can hear you.
Yes, it's this. May the commission vote on a binding recommendation from the DA and subcommittee?
Pursuant to
I think not, because it's a binding recommendation. There's nothing to vote on.
Pursuant to the statute, the commission does vote on binding recommendations because they can send it back to the subcommittee.
Okay. All right.
Bill, do you want to punctuate that motion for me? It seemed like one long run-on sentence.
I'll see you next week, Murph. We'll discuss it. We'll discuss it private.
Any further discussion? All those in favor of District Attorney Fitzpatrick's motion? 1, 2, 3, 4, 5, 6, 7. Is it only Judge McQuillan and District Attorney Murphy there?
Yes. Yes.
Isn't that 8?
8. Okay.
2, 3, 4, 5, 6. 8, yes.
8. And opposed? 1, 2, 3. Abstained? The motion passes 8 to 3. The next item on the agenda is the laboratory updates. Is there anybody that had any questions or concerns about any of the laboratory updates?
Well, I had a question about the, not sure what lab it applied to. Kathy, maybe you or Marina or anybody in the room, what are labs around New York State doing about gunshot residue analysis? Is there a simple answer to that, or is it more complicated?
I believe, I think just Westchester, Suffolk is.
New York City. New York City's doing gunshot residue.
Yeah, we send ours to the NYPD.
Okay, and they
Your
continue.
question about are the techniques that the labs are using to do.
No, I've seen, the FBI is no longer doing it, right?
That's correct.
And I was wondering if there's a consensus amongst the scientific community, whether or not it's a worthwhile test. I mean, I remember trying a case once where the issue was that there was no gunshot residue on the guy's hands, even though he had been apprehended within minutes of the crime, and this became problematic until they searched his coat and found that his inside coat pocket was laden with gunshot residue. And I thought that was a very probative piece of evidence, but now I read these journals and articles that say it's really not a probative result because there's so many things that can lead to contamination, and I'm just curious as to whether or not in New York there's a scientific consensus as to the value of the test. And I know you and I have discussed this regarding that other issue, which is there not one, or some labs do it, some labs are not doing it? I'm just wondering why two very, very reputable labs, NYPD and the FBI, would have such divergent philosophies. NYPD.
We don't do elemental analysis on gunshot residue on the hand, so we don't do that. But there are many kind of gunshot residue,
Right.
bullet hole determination,
Right.
muzzle to target distance, gunshot residue on the hand. So when you say gunshot residue, it covers.
Phil, what I'm talking about is a test, basically swabbing the hands or some other surface to determine, did this person fire a gun?
We don't do that.
You do not do that, okay.
Don't you have some really big electronic microscope that analyzes gunshot residue?
We don't do SEM EDX, scanning electron microscopy.
Yeah.
Was it the E stand for? Dispersive
Energy
X-rays,
dispersive.
refractometry. So
You
we don't.
do that, you don't do
No, not for gunshot residue.
not for okay.
With respect to Nassau County, there is a, I don't know that there's any page number identified. It looks like the second page. There's a personnel matter, which is the result of I guess a failed PT test. An inconsistency, it has to do with paint. There's an inconsistency was reported by the analyst using one of the items included in the PT, item number 4. And the result is the analyst was reassigned to the firearm section and will no longer analyze paint. Is there anyone who can discuss what the problem was and why reassignment was viewed as a sufficient response?
Do we have anyone from Nassau that can help?
We don't have anybody from that laboratory here now, but the issue, the person was in trace evidence. They were doing a number of different subdisciplines in trace.
Mhm.
And then I'm not so sure that the transfer was a direct result of a failed PT, but it was more of a transfer anyways. That was going to, there was an opening of firearms and the person decided to transfer.
That
I
sounds
believe
like
it was
finding a
the
guy
s-
with
well, I
a
believe it
unit.
was the same person who had the
Mm.
hair PT, so, I can't give you any more detail about that. We could ask, that would be Jim Purnell's laboratory. He's not here right now. There's nobody representing that laboratory.
Well, I won't be here to do the asking, but there isn't any nexus necessarily stated here, but there seems to be a situation and a response. And I think it might be beneficial to learn a little bit about, the person is not named here, so we don't have to worry about going into executive session. But is there any nexus between the failed PT and the analyst being reassigned or being found an opening in the firearms section? And is that an appropriate response under the circumstances? I think ought to be expanded upon at some point. Because what is the point of doing this and making these revelations if the result is a transfer? It may be that it was just it may be just as you say, a simple.
My guess would be that
I
they're
don't think we should
explaining
guess.
where there was no corrective action required because that person was transferred.
That's
You're
a
right.
good-
I think that's a very good surmise and may be correct, but I don't think we should be guessing.
No, I agree.
So I would ask that this be explored.
If I could comment, I think that's a good point, Ira, that we shouldn't be guessing is the timeliness of these reviews. There were some 22 labs included in these tables where summaries were provided. In the context of PT, 16 of those laboratories had no issues. They passed, no need for investigation.
Mhm.
2 laboratories were subject to minor PT errors. 4 laboratories, there were what I would characterize as major errors, where in fact there was a need for case review, staff reassignment, revised SOPs. And I don't recall in any of those instances when their application comes up for review before this commission that any of those cases in fact were discussed. Now, I may have been not aware that in fact they had been presented, but my recollection is that we did not. So it was quite a surprise to me in reviewing these tables that errors of that magnitude, potential significance, weren't previously discussed.
I have one question about the Nassau County latent print proficiency test issue. Does somebody explain what the nature of those errors were and what the corrective action was? I think that ASCLAD, Patty Williams from the ASCLAD Lab Proficiency Test Program Management indicated that it was an appropriate corrective action, but I'm just curious about, somebody could tell me what the nature of the error was.
The analyst felt there was not sufficient detail in the print to identify, so their response was that it was not, they did not identify that 5F print that was submitted in the PT. And it was an error pointed out by the proficiency test committee, because 96% of the accredited labs did find there was sufficient detail. So in that case, I believe they went back to look at previous cases from the examiner. And we brought this issue, you were at the QA subcommittee, we brought this issue up. We had 3 laboratories who had the same, almost the same thing, not sufficient detail in the print, in one of the prints from this PT, and noted that there was very different corrective actions done by each of the laboratories. So that's something that the QA subcommittee, I think, should be looking at to see if there's some sort of guidance that they can provide on how to do one of these, or to do corrective action.
Yeah, I remember there was discussion of this, and I know that we're going to discuss this whole issue later, is that right? So I should defer what I have to say.
Going on, there is a December 14th referral related to the Western Regional Crime Laboratory. This is the letter is December 14th, 2009, and in it, there's a statement that a review of the previous casework of lamp examinations by a particular analyst will be conducted. I don't see any follow-up on what the findings were. Rome wasn't built in a day, but that's 7 months ago. I think we should have some follow-up. If it's no.
Ivar, we'll get both those pieces of information and send it out to everybody.
Okay.
Or do you want to have somebody here that can answer?
The analyst did take another PT and passed that PT, but you can speak to it.
We had sent out some of the cases to another laboratory for review, and when we were searching for additional ones, we picked up a couple of more, so those are still pending.
Okay, so you're still working on this?
Yes, and we haven't found any inconsistencies at this point.
So you'll get back to us when you're done?
Absolutely.
That's great. Thank you.
Thanks.
Onondaga County. There's another problem identified. It may have an impact on some 60 cases.
It wasn't, that was completed.
Okay.
And I believe that we were provided with that. It wasn't ended up being 60 cases when we did the complete review. It was 25 cases. Of those. There were, so the problem, let me just say, the problem first of all was that we had, due to a problem with one of our methods, we had some samples that were not amplifying when the DNA is put into the solution to generate an amplified product to determine the type. They were not amplifying as well as they could be. They were inhibited due to a problem in the method. So we reviewed the case, reviewed a number of cases. There were 25 cases that required retesting to see if we would get a result with the improved method. And four of those cases generated DNA profiles. So previously there was no DNA profile generated. In those 4 cases there were. The reports were written and sent out, and they didn't affect, all of those cases were cases where there had been no suspect and no one had been arrested. So those cases basically, if they were CODIS eligible, went to CODIS and proceeded in the normal way.
Based on, there was no statement in this little summary, that's all. But thank you for the information. Moving on to Suffolk County, in the trace flammables, the glass vial containing a liquid was not removed from the clothing evidence prior to placing in the freezer. The result was that the vial broke and the liquid was not able to be recovered. It says a supervisor will issue an operational directive on the proper packaging and storage of evidence. And then it says on 2/23 a disclosure letter was written. What is the substance of the disclosure letter? Is that available to us? Who was the disclosure made to? What did they say? What was disclosed?
You're looking at the updated?
I'm looking at your terrific, things are unbelievably good.
Disclosure letter was 223.
22309, and this is in your Suffolk County Crime Laboratory in your, I forget what this compendium is called, I'm sorry.
Yeah, that, I think, information, yeah, that was submitted at the December 11th meeting. So in that packet you had from the December 11th meeting, the only updates you have are additional information that wasn't submitted in the December 11th meeting. So I do have a copy of that February 23rd letter right
Okay,
here.
I didn't.
If you need to see that.
I know, I just want to make sure there was
Yep.
follow-up. I also want to note that, if I'm not mistaken, there have been a series of issues related to the storage of evidence in Suffolk County. And this is just the last, the latest. I mean, there have been things missing, things allegedly sold. I don't know what to make of it, but it seems a continuing source of exceptions. Maybe someone ought to take a look at that. Let's see. Westchester County. And again, if there was a follow-up, I'm sorry about that. I don't have it. The proficiency test, November 2nd, 2009. It says, notification of noncompliance by the laboratory involving PTs entered into the limbs and reviewed for case status by supervisor, inadvertently unaware that these were PTs. What do we have there? Somebody speak to that?
Was this the issue that was discussed in executive session?
It may have been.
Yes,
I don't
the
see this.
December 11th.
Okay, so we dealt with that. That's it, thank you.
Further discussion on annual reporting?
Yeah, there's some things in here that I see are also in the executive session material, so we just wait.
Please. Yes, sir.
Getting back to procedure, Kathy, again, these tables are extremely useful, very well organized, have a lot of insightful information, but we see them just once a year. And errors in proficiency testing are only shared with us at that time. Is it possible through the course of the year for each of our meetings to have updates on significant, what ASCLAD Lad may characterize as a level 3, or is it level 1, the more serious of the two?
Level 1
To at
is
least be
mostly-
presented?
I think we could consider that, yes. I think that's something to consider. We have to figure out how to, there's a big process with getting the information from the accrediting body, and then they have the time for the, corrective action. So, I mean, we could try to find a way to give you more frequent material instead of 1 mega amount of material at the end of the year, so.
Because I have commented on several occasions in reviewing the assessment reports that there is a question on proficiency testing performance. Has it been acceptable or unacceptable? And on occasion it would say that there were errors in PT, but there's nothing to weigh as to its significance, lacking what the errors were.
Is it possible that, would it be easier if the Quality Assurance Committee was the first, stop, doesn't have to go to everybody necessarily, to go to the committee first?
Well,
Because
something to consider.
that might,
Mhm.
because Dr. James, you're running that committee, and you're, would be probably the best person to, to get a real-time assessment of these things. And, that might help.
No, it's a good suggestion. We'll have to talk that through.
We're always looking for the way you want this material presented to you, so we'll work with whatever way you decide would be
Okay.
it.
I think it's a great improvement, but the problem is that, you find out what the substance is earlier, and we're not just, you don't have to bring people up here in this fashion, better.
Okay. Any further discussion on the annual reports? All right, the next item of old business was put on the agenda at the request of Mr. Scheck and Mr. Neufeld. It's a letter to the editor entitled Sequential Unmasking a Means of Minimizing Observer Effect in Forensic DNA Interpretation. Mr. Scheck, I'm going to ask you to take the lead on that.
Well, I think that this arose in the context of, I can't remember which laboratory, maybe Dr. Cronin would know. Remember that there was an issue that arose about whether it was possible to interpret DNA profiles without, from the evidence, without first knowing, without knowing at the same time what the knowns were.
I think that was before.
I think that was Erie.
Was Erie? I couldn't remember.
It was a finding in one of the inspection reports.
Yes, what was that? What was the finding? I can't remember.
It's just I'm going back now,
Yeah.
my memory. And maybe Paul Mazur is here, he's the assistant lab director from Erie. It was more of there was some question that some of the lab analysts were not following protocol, which they had written protocol about how to interpret, how to conduct an exam and form a conclusion, and they just were not following that protocol, so that was the finding.
Right. So I mean, I think this is how it arose in the context of, I think, this question as to whether or not it would be possible to make essentially blind readings of the evidence samples without reference to looking at the knowns. Plainly, the value of that is that when you have these potentially ambiguous situations where you're not sure whether there's allelic dropout or not, where you're not sure whether it could be an artifact as opposed to a real allele, wouldn't it? The issue is, I think the question that arose is, that wouldn't it be better to do those readings blind, right, before you knew the knowns? Just as a simple matter of trying to minimize cognitive bias. And there's certainly a vast literature on this that would indicate that that would be the best way to do it. And what I said at that time is that I was aware that Dr. Crane and his colleagues had developed a method known as sequential unmasking, which was literally a technique whereby you could do these DNA tests so that you would first analyze the evidence samples before seeing the knowns. And this was the so I knew that they had published this letter in the Journal of Forensic Science, and I put it in the record because sent it to everybody for purposes of discussion to find out from our colleagues doing the DNA analysis why this couldn't be done in our labs, is really my question. Because I would take it as a given, unless anybody really wants to dispute it, that if one could do it this way, have blind readings of the evidence samples before knowing the knowns, that would be preferable.
Did you write it? Are you the author of the letter?
No. This letter, it was written
But
by...
this is written by these guys on the bottom here, Crane? And
Yes, these are...
Oh, okay.
These are people that are Dan Crane and Simon Ford and Jason Gilner and Keith Inman, Mark Scott Taylor, and are all DNA analysts.
Yeah, I know who they are. I just didn't know
the
they
other
wrote the
people
letter.
on the letter are people that have expertise in cognitive psychology and forensic matters who have written extensively in the area of trying to come up with forensic methods that will minimize observer bias. So this was their proposal, and I guess my question is, why couldn't this be put into place?
Any time I've ever had a DNA expert testify for me, and I've only used the state police lab or Dr. Corrado's lab, the protocols suggested here have been followed, just not with a case manager. Russ Gettig, who works for Jerry there, was phenomenal, and when the defense expert testified, I mean, even he acknowledged that that was the, proper way to go. And all of Kathy's people do that as well. I see two problems, Barry. Number one is, just cost, and, you hear that she's laying off people. I don't know if it's possible to hire a case manager to do this. And the second problem, I think, would be if I have a case, I'm going to be, reviewing the evidence up until the day of jury selection. And I may have to go back and say, look, I want another piece of evidence analyzed. And I just think it's impractical for the staff that we have available to say, okay, a whole new person and a whole new case manager is going to take over this investigation. Substantively, I agree with the concept behind the letter, and I think it should be followed by every lab as much as possible, and I think it should be expanded to other disciplines as well, not just DNA analysis.
Well, I certainly appreciate the concept that you might do a DNA analysis in a case, and then you come up with new evidence, right, that has to be analyzed.
Yeah,
and if you don't have all new personnel, they'll probably have seen the knowns in the case at issue. But, I mean, if in fact the Onondaga Laboratory is following a protocol where first you make calls on the evidence, and that's literally in your written protocols?
Yes, it is. And I believe, we discussed this at the BioTwig and at NICLAC, and all of the DNA labs, that is part of their protocol. I mean, that's the way it should be done, and everyone's doing it that way. In addition, I think it's also important to point out that only less than 20% of the time do labs even have a known standard. So, for people to think that you have these knowns that you're comparing to all the time is really not the case. So 80% of the time you have no choice but to do it without looking at the known. And those other 20% or less, the policy is to not look at the known until you establish what the question profile is. I mean, that's just normal procedure for all of the laboratories.
So, but that's in everybody's actual protocol? I mean, if I go to the laboratory and I get your lab protocol, there would be something in there that says first the analyst is supposed to make the calls on the evidence, and there's some procedure in place where the analyst will not know what the knowns are until after those calls are made, and there's actually a written procedure.
It's in our protocol to do that first. It's also, I believe, part of the SWGDAM guidelines. I don't know if the DNA person wants to second that, but it is part of the SWGDAM guidelines that they suggest that as well.
I understand that. I think we're all in agreement that that this ought to be done. My only question is there some way that we can, because I know it did arise in this one instance, is there some way that we can, as a commission, be assured among all the laboratories that are doing DNA analysis in New York State, perhaps if we could just get the protocols from each laboratory to make sure that that is in fact being done with, that would also include exceptions,
for retesting.
For instances where
But
you can't do it.
why don't we survey the labs? Can we do that?
Yeah, I think that would be a very good idea. And just to make sure that we have this in place so that it's maybe the first step towards actually formulating a policy that if anybody doesn't have these procedures in place, and after devising appropriate exceptions, that we could do it. And to your point, Bill, about how this kind of blind reading ought to be done in other disciplines, and this perhaps anticipates the discussion of our Quality Assurance Committee. Recent studies by the cognitive scientist and fingerprint expert E.T.L. Dror has demonstrated that when you're dealing with fingerprints, right, that the results are very different when the analyst does not have, the known exemplar and is just trying to identify different points on the fingerprints without reference to the target. And there's also differences depending on how smudged the print is or is not. And some of those results, incidentally, are a bit counterintuitive, but that's a significant step, and I think that we should be moving towards doing these kinds of blind readings in the area of fingerprints as well. So I'm glad to hear that we're doing it in DNA, and that's the reason I put the sequential unmasking letter in, and perhaps we can move towards some kind of a policy on that.
Okay, well,
So it does sound as though there is a consensus to have in SOPs this process of sequential unmasking to the extent that it's practical and useful. You mentioned that there is a working group that includes that among its requirements. How does that translate to ASCLD Lab and survey? It's one thing to have an SOP, it's another to monitor for compliance.
Well, ASCLD Lab, part of what they do is they look at what, they don't just look at what the ASCLD requirements are, they look at what your requirements are in your
Yes,
laboratory
yes.
policy, and then they determine if you're following your own
Right.
policy. So if your policy states that, then they will have to see documented proof that that is what you're doing.
Correct. But the question is, do all labs have that in their policy, that ASCLD Lab in fact would monitor that they're in compliance? There's the first
It's an
step.
ASCLD Lab policy that all labs are monitored to see if they are in compliance with their own
Right,
policies.
Right. But the policy has to exist.
Right.
Yes.
So what's
Are you
the
asking, does
what's the impetus
ASCLD say
for?
this policy
Right.
exists? ASCLD does not address that. The QAS standards, which are the standards for the DNA laboratories,
Mhm.
I honestly don't know if they currently address it. I don't think they address that specific issue, but I might be wrong on that. I shouldn't say. I don't believe they do.
There's emerging technology here too, folks. There's computer-assisted mixture deconvolution. There's 5 flavors of it that are a year away, depending on which lab is doing it. A lot of what Crane is talking about is at the core of the algorithms that they use, the process that they use. Not exactly what Crane is writing about, because Crane didn't write a protocol. And it may be appropriate in some ways to send this to the DNA subcommittee to say, how can we in New York ensure that, that observer bias is minimized in mixture interpretations in labs in New York? Maybe that's the place to look at this, because there's a disconnect between a letter to the editor and the actual protocols where they intersect switch game changes and the new computer-assisted deconvolution programs.
No, I quite agree with that, and perhaps that's the best way to do this, in conjunction with the Quality Assurance Committee. I mean, what I'm taking away from this discussion, which is extremely helpful, I think, is that, the way that we structured this commission was that we have New York State accreditation, and then we delegated out to ASCLD, an accreditation process that we in turn review. But the concept was always that New York State would be able to, in a sense, set a higher standard, because by necessity, when you're coming up with standards for all laboratories, it goes down to the lowest common denominator to some extent. But if we want to have higher standards, then we can do it. And what I find useful here, if I understand, Dr. Trotter, what you're saying, is that once we put a protocol in place for, let's say, blind readings of, to the extent practical, of DNA samples or fingerprints or anything else that we are able to develop over time, then ASCLD Lab will, in fact, in a sense, administer that for us. They'll inspect whether or not we are following our own protocols.
The laboratory protocols. I don't know that they would necessarily, if the commission came up with something, I'm saying if the laboratory has that in their protocol, then ASCLD Lab will hold you to that. Are you doing that?
No, but what I'm saying is that we do not have the capacity in this commission to go out and do laboratory inspections. It was never contemplated. We're not funded to do that. My God, we're practically, are we funded even to be here sometimes, I wonder. But what we can do within the ASCLD system, right, is if New York State says, here's our quality assurance, here's what we want to do in terms of blind readings and any other quality assurance measures that we adopt for New York State, this commission would have the authority to develop these standards and ask the laboratories to conform with them. And then ASCLD would go ahead and do the inspections to make sure that our labs are living up to their own standards. Isn't that right? Isn't that the way it could work?
They could.
All right, well, why don't we do that?
Well, weren't we going to start with a survey of the labs to see what their standards are already? Who's got what on the books in terms of their written policies and protocols, and come back and report on that?
Well, I would take the amendment here. I think that maybe as far as the DNA is concerned, maybe the best way to proceed would be to ask the DNA subcommittee, A, to conduct that survey for us, because they should be able to do that pretty quickly, and B, I would move in consultation with Dr. Crane and his colleagues, who have written a provocative letter, and written well in this field, but do not necessarily have I think they might actually have some kind of protocol for this, but they could share that with the DNA subcommittee, and we could ask them to report back to us on what the best way would be to implement blind readings, with caveats that make it practical.
But I mean, I think the point is we're already doing that, so I don't know what we're asking them to do.
Well, no, I completely accept that your laboratory is doing it. We don't have an answer if all laboratories are doing it, and the way that we should set standards is let's send it back to the DNA subcommittee so that they can make sure that there is a standard, and that standard is followed by all laboratories. Isn't that the way it should work? It's a great suggestion.
Well, the DNA subcommittee did look at this issue.
Yeah, there's
We have a
a letter.
letter from them
Saying?
saying that they don't think any changes are necessary.
Oh. They say that we don't need any changes?
Well, yeah, they said that we don't need a case manager. Did they say, Gina, that they surveyed all the labs?
No, they didn't survey all the labs, but the Office of Forensic Services would actually do that on your behalf or on their behalf, so.
Yeah, why don't we do that, Barry, and then Barry, your point is if ASCLD Lab doesn't mandate this as an accreditation standard, we could.
Right.
Yep. So I would say the first step would be to find out what the labs are doing.
Okay.
Okay?
Yep, that's fine by me.
All right. Now we're moving on to new business. And the first order of new business is an update from the subcommittee looking at dedicated funding streams. And that's chaired by District Attorney James Murphy from Saratoga County. James Murphy.
Oh, okay. Are we on? Okay. Before I start, could you tell me whether or not either Steve Aquario or Travis Franti are in New York City?
No.
No. Okay. That's fine. I just wanted to make sure because they might have additional information. They said they were going to try to make it, although given the present status of the budget, I'm sure Travis is busy. But the committee was established to look at a permanent funding stream for the labs, given certainly the dire consequences and situation that we're all in relative to funding, not only just county and state, but the labs in particular. At our last meeting, we had, since the full commission meeting, Travis and Steve attended. Travis is obviously from the Division of Budget, and Steve Aquario is the president of the New York Association of Counties. And it was very beneficial to have them at the meeting because they stopped in to learn a little bit about the labs. They had no idea, I think, to the degree that the labs were in the funding situation that they were in, and possibly that much of the funding might be pushed back to the counties or the DAs or law enforcement agencies to try to keep the level of quality that we have and to improve the quality we have was possibly in jeopardy. So Sean was going to meet with them at some point and kind of brief them and have somebody at DCGS brief them about, kind of a Labs 101 course for them and to let them understand, to make them understand what we did and why it was important and why quality assurance was important and why high standards were important. Travis, I think, had previously looked at lab funding proposals over the years with DOB, had rejected various kinds of proposals to include funding them with forfeiture monies, to include funding them with a per item submitted type of proposal, as well as trying to consolidate forensic services in different regions. And he was going to reach out to the lab directors directly to touch base with them to find out what specific funding needs they had and then report back to the committee. Dr. Corrado and Dr. Saji were also at the committee, and they had planned to speak with NICLAC, the lab directors, and to get information from the lab directors to present to DOB and NISAC, and to try to obtain from the lab certain specific things. What was the percentage of the budget that was for payroll? What was the percentage of the budget that was from local versus state funding streams, or federal funding streams perhaps, and to identify those individual funding streams. And I understand that DCGS was going to help them kind of identify that. And then they were going to bring that information from the labs back to the next NICLAC meeting to talk about it with the lab directors. And Kathy and Marina, if there's anything I've left out on that, let me know. That was the entirety of the meeting, and we're scheduling another meeting between now and our next commission meeting, when we'll have that group of people come back and report as to their findings.
Very good. Are there any points or conversation with District Attorney Murphy? Follow up on this? Hearing none, I think we'll move on to the next issue, which is an update from the Commission Subcommittee on Quality Assurance. And we'll be hearing from Dr. Jenny in that regard.
Thank you. The subcommittee met in April. There were some 14 individuals in attendance. We had good representation among commission members. We had good lab representation, of course, DCGS, OFS. This was our first meeting, and there was discussion on the purpose and role of the subcommittee. And there is a late addition to your packets. I apologize, but you do have the minute summary. So the initial discussion was on the purpose, the role of the subcommittee. Gina and Kathy provided an overview of the statutory authority for the commission, its responsibilities, the policies and procedures in OFS, more or less laying the stage for what authority we have in our activities. So members did discuss the impetus and role of the subcommittee, and there were accepted that the principal cause for the subcommittee was the apparent increased prevalence of events in forensic laboratories that has required investigation into the integrity of lab services and the downstream consequences of those substandard lab practices. Secondly, we all know that the National Academy of Sciences published its report in 2009 on strengthening forensic science, a path forward. And finally, this commission, often in its review of accreditation reports, there are questions of practices and how they may be improved. And many of those suggestions or inquiries are due careful consideration, and it was felt that this subcommittee could take up some of those charges. So with that as background, the committee did discuss the development of an action plan, and there were 5 broad categories for discussion. The first, mitigation of risk for lab error. Second, investigation of nonconformances. Thirdly, proficiency testing. Fourth, National Academy of Sciences, the path forward. And lastly, the access to expertise and, of course, resources. So the first category, mitigation of risk for laboratory error, we did briefly review the table that's been prepared for this commission, the table of forensic laboratory external investigations. In review of those cases, it's fairly evident that there are practices that are implicated as root causes. And among those, the training and competency assessment of staff, technical review of work product, internal audits for compliance with policies, procedures, and work quality standards. So we identified those as important charges to the subcommittee as to what are current practices in laboratories, and in fact, can we identify best practices that may be adopted by laboratories. So in your minutes, we did identify the first action item, and that is to survey forensic laboratories for policies, procedures, and personnel training and competency assessment and the technical review of work products. Survey lab management for internal audit policies and procedures, and the management reviews for continuous improvement. And these surveys are to be done with an aim to identify best practices that can be adopted by laboratories. Secondly, under mitigation of risk for lab error, there was a discussion of the important role of the quality manager in laboratories. And concern was expressed that in some laboratories, the duties and authority delegated to the quality manager may not be consistent with the important responsibilities in that role. So in that regard, the action item is to survey forensic laboratories to collect job descriptions, duties, and performance evaluation criteria for quality managers. And again, surveys are to be done with an aim to assess best practices regarding duties and delegation and authority to those quality managers. All right, the second topic of discussion, investigation of nonconformances. No quality system is perfect, of course. There are breakdowns in quality systems. Lab errors do occur. There is, on occasion, a need to investigate those nonconformances. And over the past 2-3 years, this commission has had discussion on proper design in investigative protocols, including sampling of cases where reanalysis is required. So as not to let that important topic fall off the table, we included among our action items cited here as reviewing published literature on the topic of retrospective analysis and sampling design to characterize the reliability of case reports. Seek collaborations to develop a guidance document on protocols to investigate the consequences of non-conforming lab practices. If there were an easy solution, we would have had it by now, obviously. It's clearly going to require collaboration with statisticians and lab professionals, and we hope to undertake that project. The third broad topic, proficiency testing. As we know, accreditation programs use approved PT providers as a tool to assess lab performance. I think we as commission members and certainly OFS staff have noted that there may not be consistency among providers in accreditation programs with regard to the definition of what constitutes successful or satisfactory performance and proficiency testing. And when in fact errors are identified, are the requirements for the rigor of investigation of unsatisfactory performance consistent among accreditation programs and PT providers. So an action item is to review provider and accrediting organization performance standards for proficiency testing with an aim toward ensuring that the threshold for successful performance and the investigation resolution of unsuccessful performance are of comparable rigor and timeliness. Fourth topic of discussion, National Academy of Sciences, the path forward. I believe there are 13 recommendations made by the committee. We discussed 3 of those during the subcommittee meeting. The first, identified here as recommendation 2, in the Academy report, it certainly acknowledged the importance of laboratory reports and the terms used to describe the evidence found and the conclusions drawn. Nationally, there's wide variability across the scientific disciplines. The National Academy Committee is recommending the establishment of standardized terminology and reporting used in testifying about and reporting on the results of forensic science investigation. The committee questioned our laboratories in New York State subject to the criticisms that were raised in the Academy report. Recommendation 3 from the National Academy. Studies are needed to establish the limits of reliability and accuracy that analytic methods can be expected to achieve as the conditions of forensic evidence vary. I'm sorry that Barry's not here. He raised an important study. In fact, it's an NIJ-funded study awarded to doctors. No, I don't think Jennifer is a doctor. She's an attorney. Noonkin and Dr. Dror, who have been funded to study error rates in fingerprint evidence, where in fact blind testing will be used as a part of their research protocol using real-life samples. So as best they can mimic real-life conditions in fingerprint analysis. Barry suggested to us that in fact there may be opportunities for laboratories to volunteer in that research project. And we agreed that we would poll laboratories performing latent print analysis, whether in fact they would be interested in participating on a voluntary basis in that study. And third National Academy recommendation that was discussed, quality systems should be designed to identify mistakes, fraud, and bias. Quality systems should confirm the continued validity and reliability of standard operating procedures and protocols and ensure that best practices are followed. And the subcommittee members agreed that a principal role of our activities is to facilitate fulfillment of that recommendation in New York State. So I have just 2 action items listed here with regard to the National Academy report at this point. I understand, actually, from Gina that there is a joint task force and a national committee reviewing lab reporting practices, and that, in fact, we as a subcommittee and, of course, the commission will monitor those activities, review national protocols, and hopefully translate those national efforts to New York State purposes. Recommendation 3, inquire on opportunities to participate in the NIJ-funded study to assess the reliability of fingerprint identification and poll New York State labs on their interest for participation. And the last topic of discussion, access to expertise and, of course, resources. The subcommittee did recommend that a roster of subject matter experts be prepared. Those individuals who may be interested in making presentations to the commission with the purpose of informing us on advances in technology, best practices, accreditation program standards, and of course the accomplishments being made under the National Academy funded projects or recommended projects. I have to say, and this was actually made very clear very early in our subcommittee discussions, of course any change requires resources. And that's not lost on any of us. Change and new requirements, they do incur cost. I certainly believe in Deming's position that quality is free. Perhaps with identification and adoption of best practices, I would like to think that some of these cases that are now under active investigation by OIG and had previously been investigated may never have occurred. There's tremendous cost, of course, in recovering from errors in nonconformities. So best practices, of course, they are designed to mitigate risk or minimize risk for laboratories' errors. So we hated to conclude on somewhat a down note in that as much as we'd like to accomplish, engage laboratories and OFS and, colleagues around the country in working to identify best practices and lead toward their adoption, it does require resources, and our activities, of course, will be limited by the availability of those resources. So that, in essence, covers the discussions. It was a good, I think, 4.5 hours of talk. The outcome, in essence, is to collect information from our laboratories as to what their current practices are. Perhaps in that data analysis, we'll identify across the scope of laboratories practices that others would be interested in. And then again, identify or compile and make known to the lab community what might be considered best practices. This is an evolving agenda, certainly ample opportunity for anyone to comment on what might be added to the list of action items. In fact, may provide some insight as to how those action items might be modified to make them, well, more effective or to increase the chance for their success. We also expect to meet before the next commission meeting. I did discuss next steps with Kathy, and the obvious next step is to design survey documents. I believe Kathy has accepted the responsibility for drafting survey instruments that will be shared with the subcommittee for its input, and hopefully before the next commission meeting, those documents will be available for review by the commission. Okay.
Thank you very much, Dr. Jenny.
Yeah,
Any
nice to
discussions for the doctor?
That's a lot of work.
Dr. Jenny, thank you. Excellent. May I just make a reference to a recent independent study on fingerprints within the past week or so. The Houston Police Department fingerprint latent unit, an error rate of an appalling 50%. It's unbelievable.
Babe Ruth made out 74% of the time. Judge, you know what the hell? I'm sorry, it's bad.
Well, you know, I mean, and it all depends on how you define error.
64% of the time, I'm sorry.
It all depends on how you define error, because if an error is a failure to detect a print.
They included that, Barry.
I know, and so before we start laughing at Houston, we've had plenty of
I
that.
wasn't laughing. You said, look, I understand that 90% of these are guilty people not being identified, if not higher, right?
That's right, and there will be the occasional person who's tried, where somebody's come into court, as we saw in our New York City problem with lab analyst Martin. The people come into court and they'll say there was no print on the gun or the object, and there was, and if it's not the defendant's, then that's
Or
exculpatory evidence.
your Rochester case. They had the murderer's print and didn't even run it through safes.
Yes, and let me apologize for stepping out. I actually got a call from a judge, but that judge actually involved a case in Louisiana where there was a failure to identify a print that should have been identified that would have exculpated somebody.
What'd you do, tell him to call you at 3 o'clock? Is it?
It was a she.
Oh, just tell him, sexist pig that I am, thank you. But you told her to call you at 3.
So let me apologize, Dr. Jenny. Did you mention the possibility of participating
Yes.
in that proficiency test with the people from NIJ?
Yes, I did. And during the committee meeting, it was unclear to me, and I think to others, whether in fact there are opportunities to participate. That I did find on the web a description of Dror and Mnuchin's funded project. And there are 4 phases that go through 2012. I don't know where in the process they are and which of those 4 phases there would be opportunities for laboratories to participate. So I think we're looking for some guidance as to whether in fact there are opportunities to participate in that study, and if so, how do we avail ourselves of them.
Right, and I will try to get them in touch with us and see if they can do it.
Any further
Yeah.
Pardon? Oh, yes.
I
Dr.
just have one
Corrado.
comment, and I feel I would be slightly remiss if I just didn't bring this up, and that is that there are a number of laboratories in the state that are accredited in latent prints, but there are also a number a very large number of unaccredited agencies performing latent prints in New York State
Yeah.
as well.
In fact, that was discussed in the
Yeah.
subcommittee, and it's noted here in the minutes that you have that there are practitioners in the laboratory and outside the laboratory, and our scope of oversight doesn't include all latent print practitioners.
And just for the record, I think that's one thing that the state legislature should do, which is that they should expand the jurisdiction of this committee to include the people that collect the prints and the other entities that technically are not in laboratories, but in police departments who are doing this fingerprint analysis, because it's of such tremendous importance. So I think we all support that.
Any further discussion? Thank you very much, Dr. Jenny. The next item of new business is the chart of external investigations. Do we have either Kelly Donovan or? Okay, Kelly, do you want to discuss any of these items with us? Pardon me?
Executive session.
Oh, we'll do that in executive session? Okay. All right.
Kelly with the Inspector General.
Okay. I am reminded that we're going to cover this in executive session. And so at this point, I would ask anybody that doesn't have an item that's going to be reviewed in executive session, to please leave the room. Those of you that have executive session items, pardon me? I understand. I'm sorry, we're still in executive session. These folks are all involved in the executive session. Not a problem. The gentleman was a reporter.
Oh, would that be a problem?
Okay, we're back on the record. We've been in executive session. We've been discussing cases that may result in disciplinary action or criminal prosecution, or affect criminal cases. There was no action taken that would require public disclosure at this point. Our next meetings, for your calendar purposes, are September 22nd in Albany, New York, and December 7th here in New York City again. I want to thank all the members of the Commission for their participation in this meeting and for making it go very smoothly. And I want to again commend Commission member Ivar Goldart for his tremendous service to this Commission for 16 years now. Thank you very much.
Thank you.
Thanks, Ivar.
Thank you.
Thanks again.
Thank you, everyone.
Thank you.
Cash bonus or?